games. I'm serious.
You are playing games, and first of all, you don't.
I'm trying to advance to
all right,
what
stop.
I'm
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well, this crazy stuff you're saying, I've got very little patience for it. This is not civil procedure.
It's the Sixth Amendment grants me the right to know the jurisdiction being applied.
And I told you what it was.
And it gives you the duty.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt, and you're going to go to jail.
Objection, please.
Right out of the gate, this judge is setting the tone. Control the courtroom, or you're out. When a judge says, take him, that's not frustration, that's authority in motion. Courtrooms run on structure, and the moment a defendant starts resisting that structure, the judge has legal tools to immediately shut it down. And just like that, this isn't a conversation anymore, it's a power check.
Don't talk to him. Court calls the case People versus Thomas Styron.
I'm Stunt, the living man. I'm here by special appearance to address this matter.
I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm in my papers. I'm here to address the matter.
All right, thank you. Wish to be represented by an attorney?
There it is, the living man argument. If you've watched enough of these cases, you already know where this is going. This is a classic sovereign citizen tactic, separating the real person from the legal identity. Sounds clever, but legally? It carries zero weight in court. And you can already feel the judge's patience thinning, because she's heard this script before.
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen, if you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No.
Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
Ask for the interpreter.
Yes, is it for the last two cases?
Yes.
Yeah, that one we'll swear in.
For interpreter, you're in front of the Honorable J. Cedric Simpson out of the 14th District Court of Washington County, State of Michigan. Our number is.
Get somebody from security to check back there.
She's got a shirt on. So I'll take it. So I'll deal with him. I'll take the cuffs off. Get an opportunity.
I don't know that we're going to be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things.
And just like that, bond revoked. This is huge. Bond is what allows a defendant to stay out of jail while waiting for trial. Lose that, and your freedom disappears instantly. Notice what caused it, not the charges, but the behavior. This is the courtroom reality most people miss. How you act in front of a judge can matter just as much as what you're charged with.
To make it difficult to bring him out, what I'm going to do at this point, wait, and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024. 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to go back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
I am Tariq Smart Tariq Day, the executor of the Tariq Smart Tariq Day Living Trust and the registered owner of the Tariq Smart Tariq Day Expolacione Kindaman Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
Pause right here. This is actually one of the most important warnings a judge can give. Self-representation sounds empowering, but legally, it's a minefield. You're expected to follow the same rules as a trained attorney, without the training. And when the defendant says, "I do not understand," that's not just confusion, that's a red flag that can shift the entire direction of the case.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the government should...
Sir, you have no authority for what you're about to state, because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No, sir, what you're about to state is incorrect.
Well,
if you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is...
This is a major turning point, competency evaluation. When a judge questions whether a defendant understands the proceedings, the case literally pauses. Everything stops until the court determines if the person is mentally capable of standing trial. And here's the twist, this isn't a punishment, it's a legal safeguard. But it also signals that the judge believes something deeper is going wrong beyond just disagreement.
It's mine. We are not on indigenous lands, subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers, agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. Not how it works. I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
Or ask the people to prepare the order for the competency.
Yes, please prepare the order for the competency, if you would, sir.
And the address for
The defendant.
I see on the complaint is 14.
Is that your address, sir?
Excuse me? That is correct.
All right. All right, very good.
So I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th. You were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
Well, you
You
asked.
knew that. No, you knew it was supposed to be filed before the day. Young man, you're going to
That's
figure out something. We're playing by my rules, not yours. So you do not say anything, because you're going to figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay. No problem.
Is that it for me? Thank you, Ann. Thank you, Alan. Thank you, Em.
Let's go on the record. All right, we've had a busy afternoon. We did a criminal sexual conduct preliminary examination with a child witness, which took us a couple of hours. We didn't live stream that for apparent reasons. We did deal with another matter, and we're about to deal with the last scheduled matter of the day, and I'm going to start over again. The title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended is a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here on as sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray All
right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime an autograph is to be done in a certain manner that I have here, or it's forgery, could you ask the judge, please? That's mine. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan beneficiary with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it. Mr. Marvin will sit down and talk with anybody, whether they're an attorney or whether they're a layperson. So you and he have been meeting to discuss this. Mr. Marvin, is there a plea offer here?
There is. And I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down. And so this is dragged out a bit, but only because she's not represented. And in these three separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan, and I've offered that. I have the feeling she's going to take it today, but if not, I've got my officer and we're ready for prelim.
He's offering to reduce the driving suspended charge, and he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim. I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the...
It's a benefit. And
no, before that, about the license.
He's dismissing it, and it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it, and that's a benefit. He is offering to reduce the felony charge to a misdemeanor, and that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officers have been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's just put on a
prelim. I'm serious.
You are playing games. And first of all, you don't...
I'm trying to advance to
all right,
what
stop.
Here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So, do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office.
To do what?
To if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well,
And
do you want me to appoint an attorney for you, or would you like to represent yourself?
So may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution, and I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed, and I would like it in writing, please.
Thank you. It's not civil procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to. But you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report bond information that I came with the file. What would you like to do here today? Do you wish to represent yourself?
Thank you. I do. I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay? So I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All right,
under
stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's
procedure.
the Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, please.
Please,
We're going to
sir,
talk
may
about
I?
this
The
tomorrow at 3 o'clock. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be held
right
in
now,
contempt,
and we
sir.
will. Well, you have been.
I'm simply
This matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward with
jail.
this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. And you will be more respectful to the court.
I
You
can
will speak.
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
If you want to
with the
continue,
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We
arguing.
will address this tomorrow at 3 o'clock.
Stand up and put your hand.
No,
I can't get her aspects she has there.
they'll get them for you. You can give all the paperwork to him.
Thank you.
Mr. Marvin, I don't know what you've got tomorrow at 3 o'clock, and I don't know what I have, but we'll take another shot at this tomorrow.
Justice takes time.
Just misunderstood.
Yeah, I don't know what's going on, and I don't think this was a fair trial.
We haven't had a trial yet.
A fair preliminary.
We didn't even get there yet.
This one.
Yep, absolutely. There we go. Yeah. Okay, we're gonna go over here, Ms. Keenan. Yep, I'll get all the property for you. I'll go right over here.
Here, fill my pockets. I have a key.
Listen to the office. Yep, I will get all the property from you, ma'am, and whatever property you want to release to your son, I'll be more than happy to. She's going into custody for contempt.
So that's fine.
Watch out for this chair here. There we go. Go ahead and watch your foot. There we go. That's it then, is court over?
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And that, I think it was a misunderstanding of how to, for her to be able to pronounce that. But,
Well, I told her to stop, and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's going to contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock, and to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admiralty law.
Please have that record still, or that chart, that option still, if I talk to Mr. Marvin.
I guess so. Well, you can't represent her as a lawyer,
I know.
but he could. Yeah, Mr. Marvin wants this to be over with.
And there it is, contempt of court, immediate jail time. This is what happens when courtroom warnings are ignored. Contempt isn't about the original charges, it's about protecting the authority and order of the court itself. What's striking here is how fast it escalates, a few interruptions, and suddenly it's 24 hours in custody. So ask yourself, was this about legal strategy, or a complete misunderstanding of how courtrooms actually work?